Thank you. Thank you. Thank you for having me here. Thank you for the invitation to Mary and Claudia and the others. I appreciate the opportunity to talk about this stuff. I'm going to have to figure out my space here because, of course, I had this all written out and printed out, and then I changed it. So I'm going to have to read it off of here. But fortunately, I took the time to raise the font a little bit so I can actually see it. Thank you, Vince, for running through my slides first so I don't have to. No, I'm just kidding. And I do appreciate the context that you provide in terms of the history and contemporary realities from OST. From that perspective, I put together, a number of years ago, I put together a, what did we call it? A think tank, something like that, at the School of Advanced Research up in Santa Fe, and brought together a few of the people that I have known and some others that I only met at the think tank to just talk about how to move forward, what are next steps, and I feel like that's so much of what this conference is about is next steps. And as part of that conference, we took a trip. This would have been 2013, so it wasn't that long ago. But we took a day trip down to Albuquerque and visited the call center. And I got to say, some of those folks, some of whom I'll talk about a little bit today, have been doing this work in the trenches, so to speak, for many, many years, and I have huge respect for them. And they've taught me pretty much most everything I know, and they were impressed with the call center and the enormity of that task, that job, and so kudos to OST. That said, a lot of what I'll have to say, from which I'm sort of doing a process of reportage today, is there's still a lot of criticism, of course, out there, which I'm sure you expect. And there's even more so than the criticism, I think, is just the mistrust and the sort of assumption that things are not really what they seem to be. So I'll try to always contextualize that in the fact that you all have a lot more knowledge about these things than I do. So when I was finishing the manuscript for my first book, Unearthing Indian Land, and this university was the publisher of that book, they asked for a title. And so I provided the one that forms the main title of this talk, A Spoonful of Dirt, which I still like. I don't remember what the subtitle was, but the title was the same. My editors liked the manuscript, but they didn't like the title. The explanations for why they didn't like it was something along the lines of salability, like who's going to buy an academic work with a title like that? So I took the title around to my colleagues, to the landowners whose experiences and wisdom form the heart and soul and the blood and guts of the work that I've been doing. And I asked them what they thought. Most of them agreed with me that Spoonful was as good a title as any. It's what they tell us at the BIA. And I'm not BIA bashing or anything here. I'm just reporting on what people said. They say when we go to ask about our land, and this was years ago, okay, so when they go to ask about our land and who's using it and for what, they say, why do you care? You only own a spoonful of dirt anyway. But one of those people disagreed, and she said that she agreed with my editors that it wasn't a good title, but her reasoning was a little different. She said that we don't want to do anything to further minimize the already minimalized. I didn't argue the point. I just dutifully changed the title. But now I'm trying to take it back. I want to, and for a couple of different reasons. I want to call attention to the ways in which landowner interests, I should emphasize, whether specifically with regard to Indian land or more broadly, as in what landowners say they want and don't want, are indeed being minimalized by a federal system that seems to serve everyone but them. The de minimis, the sort of legal characterization of de minimis, is something that's sort of too small to even worry about. That characterization of fractionated interest continues to be galling, and I'm speaking again from what I hear from landowners, that it continues to be galling is when a tribal member at a very recent meeting on the new rights-of-way regulations asked why allottees had not been invited to that meeting. The audience was mostly composed of pipeline and utility company officials, representatives, and she was told, allottees don't need to know 25 CFR Part 169. They're going to lose their land anyway. So by reclaiming a spoonful of dirt, I also want to call attention to the fact that on the one hand, a fractionated interest, if partitioned, might represent a home site. I mean, 5%, which is the cutoff, right? 5% of 40 acres is still 2 acres. That's a pretty big spoonful if partitioned. And yet, that's the cutoff where the willing seller piece of the land buyback program transforms into forced sale. Now, I realize that interests can fractionate into much smaller, quote-unquote, pieces than that, interests. And for those, some landowners have no interest or use and would rather have the money. Other landowners fall outside of the 2-degree mark in terms of descent and so don't qualify to inherit land under APRA anyway. But there appears, from what I'm seeing, to be a whole lot of others who don't necessarily consider the quantity of land they own. Rather, what they want to maintain is simply a connection with family and culture and place. Terry Beckwith, who I'll talk about more later, describes it like this, and I want to thank him in absentia for sending this in an email just the other night, because I think it's really poetic and beautiful. He says, and I don't know how to pronounce the name, I haven't been able to get in touch with him, but he says, I own an interest in Wynooch George allotment. Does anybody know the Wynooch George allotment? Can you tell me, anybody Quinault here? Okay, so we'll say it's Wynooch. The Wynooch George allotment. Wynooch was born in 1822 and died in 1912. The only other information I know about Wynooch is that he was married to a Chinook Indian. I have a photo of her. He's a real person, and it's important to think of him as a real person. He was a cousin to my great-great-grandfather, Jack Williams, born in 1851. Jack Williams never sold the allotment of Wynooch George. My great-grandfather, Pete Williams, never sold the allotment. My grandmother, Lizzie Williams Beckwith, never sold. My dad, Leslie Beckwith, never sold his interest in the allotment. This allotment and all the other allotments are important to us. If we sold the allotment, it would be like selling a part of Wynooch George. So for today, I was asked to discuss alternatives to the Department of Interior's land buyback program and will writing. And I realized kind of as I was listening to Vince and what I really, the subtitle really should be alternatives from landowners, because I think that's where the ideas are coming from, is from the landowners themselves, from allottee organizations, and from the people whose lives are directly affected by this. So the land buyback program and will writing, two of the main efforts to deal with fractionation with that crisis brought about by the General Allotment Act of 1887. I'll talk a little bit about things like gift deeds and inter- and intra-family exchanges, as well as tribal land exchanges, Section 17 corporations like the Tribal Land Enterprise at Rosebud, and even co-owner purchasing allowed under tribal inheritance codes like the one at Umatilla. These are some of the ideas that are coming partly from the tribes themselves and landowners. But you're probably all aware of such anti-fractionation tools, and some of you, many of you, have no doubt used them or helped to put them in place. So I'll take this also as an opportunity to explore the larger context of land management, and landlessness from the perspectives of Native landowners, whose lenses I attempt to peer through as I consider the question of alternatives to the ongoing federal, what I think of as federal experimentation with individual land tenure, which is to say, with Native people's lives, livelihoods, cultures, and familial heritage. So, to take back my slideshow, in October this past year, the Indian Land Working Group, ILWG, which I've been associated with through friendship as much as anything for close to 20 years, it celebrated its 25th annual Indian Land Consolidation Symposium. And some of you I know have been to these. I recognize some faces, a few of you I know from those gatherings. As Chris Stainbrook of the better funded and so better organized Indian Land Tenure Foundation once said, the ILWG has always had its thumb on the pulse of Indian country. The organization started as a result of a meeting of Indian landowners from around the country at the Umatilla Indian Reservation. And so come full circle, some of the group's founders at this meeting were on hand and were handily celebrated at its 25th gathering. Helen Sanders, who's on the right, on the left there, on your right, and of USV Mitchell fame, and Ernestine Wirlis, who was the founder of the Fort Hall Landowners Alliance, which has since dissolved. And together, because of their work with Indian Land Working Group, are known as the Allotment Queens for their untiring work with other Indian landowners, their fearless use of the courts and regulations to help landowners stand up for their own rights. And there lots of stories that have come from these two, and that I would love to just spend the whole time just talking about the many experiences that they've had and have shared with people over the years. I think of them sort of as bookends. They're two really, really lovely people. So it's against the backdrop of their and other landowners' tutelage that I approach the discussion of the land buyback program specifically, and of the Cobell Resolution, the American Indian Probate Reform Act, and the United States Federal Indian Trust in general. In general, this is the upshot of what I hear from landowners. They say, and they're usually talking about local BIAs and sometimes national offices. They tell us what's going to happen under APRA if we don't sell our land, but they never tell us what's going to happen if we do. One of the folks I spoke with when I was at the conference back in October is a woman named Roberta Connor, known as Bobby Connor. She's director of the Tamashtlicht, I think that's how you pronounce it, Center, the Cultural Institute at Umatilla. She says, and she's referring to Alatis who lost their land along the way, and that land went to the tribe in those instances. She says that allotment extinguished personal wealth by transferring it to the tribe as nation state before it was a nation state. Likewise, she and others worry that the land buyback program is continuing this extinguishing of personal wealth by encouraging people to sell rather than explore, interfamily exchanges, and thereby consolidating interests within families and preserving familial and cultural heritage. And when she's talking about personal wealth, she's not just talking about money. She's talking about the wealth of a place where you belong, the wealth of family, of that cultural heritage. The Confederated Tribes of the Umatilla Indian Reservation, which I remember when I was first being introduced to this world. I went there with Ernie Wirlis and on the way to a Indian Land Working Group meeting, and this was back in the 90s, and they were just beginning to really flesh out and develop their GIS capabilities, their kiosks where landowners could go and access their own information. So They vary. They're one of the tribes that very early on, I know most of you know this, were very much thoughtful about how to empower landowners to access their own information and plan with that information. So in there, as was pointed out at the conference this last year, the Confederated Tribes has their own inheritance code, which of course more and more tribes are doing that now too. And in that code, it says the tribes seek to encourage and consolidate tribal member ownership of trust lands on the Umatilla Indian Reservation. You can access that online, the inheritance code online. It's just simple. This enables co-owners to purchase fractionated interests instead of the tribe, thus keeping individual Indian lands in individual Indian hands. So leaving aside for the moment the more sort of philosophical and ethnographic and economic maybe question of individual versus collective ownership and what we mean by collective and things like that, there's a practical question of how current policies purporting to fix a prior failed policy essentially, or at least the perception is, that they essentially punish the people who were the original subjects of the failed federal policy in the first place, that is allotment. So as you know, the problem is that there is very little, if any, financial support for those tribal members who seek to consolidate their individually held interests within or between families. The only support there is comes from COBEL, a case brought by and on behalf of individual Indian landowners, and it goes directly to tribes, not individuals, which is, of course, an irony not lost on landowners. In fact, the Interior Department doesn't even consider inter- and intra-family consolidation to be consolidation, at least as concerns the availability of buyback funds, even though efforts have been levied toward educating landowners in the management and co-management of their individually held lands. And I look forward to hearing more about some of the financial education efforts that Vince will talk about tomorrow. So for landowners who are interested in keeping and consolidating their land interests, there just seems to be little help beyond what tribes and tribal members provide for themselves and for each other. So this is from an old manual, actually, the Estate Planning and Probate Manual developed by Teresa Carmody and Indian Land Working Group a number of years ago. Indian Land Working Group kind of went through some tough times there, and so it lost its website. So there's now a website. Again, it's not as well developed as the old one was, but so this manual is actually available on Indian Land Tenure Foundation's website under their Lessons of Our Land series of web pages. And still probably needs to be updated, but still has some useful information and some nice illustrations. So things that people are doing for each other and tribes are helping. In some cases, sometimes it's just the landowner organizations themselves who are doing the work. And to be sure, Indigenous Peoples Law Clinic here at the University of Arizona is a prime example of how public institutions can also help. And I'd like to come back around to this topic of self-help, for lack of a better word, at the end of this discussion. But first I want to take us on just a little side tour and try to keep track of the time here. So a little context. Ever since allotment created the problem, and certainly since Mitchell II clarified the government's trust responsibility to individual Indians, the Department of Interior seems to have looked for ways to get rid of that responsibility. And I'm really going back in time here a little bit, and probably I won't share all of this necessarily because it's pretty much of a downer. But I had an opportunity to interview Judge Lamberth, the original judge on the Cobell case, back in 2011. And it was the day after the Cobell settlement fairness hearing in Washington, D.C. And I asked him what he would recommend that the Department of Interior do to reform itself in order to come into compliance with fiduciary standards. And what he said is, like I said, I may not read you this whole thing, But he starts out by saying, I give up. He says, there's nothing I could make them do to come into compliance. Nothing I ever did could make them come into compliance. My feeling is that it's hopeless. I don't have an answer to the question. They pay lip service. So he goes on in that vein. And I am hopeful that because OST didn't exist in the form that it did, that it does now, it didn't exist in that form yet in 2011, that I'd like to follow up with the now senior judge, Lamberth, and see if he's followed along. But the thing is that I still hear the same complaints or similar kinds of complaints from landowners as I've heard since the 1990s when I was first introduced to the morass that made Cobell necessary in the first place. It was around that same time that I was told that Interior, and I was told this by an attorney who works closely with Interior, and said that he told me that Interior would eventually force Indian landowners into writing wills, regardless of their culturally based resistance to doing so. I'm not saying that will writing is a bad thing. It's just, as you point out, it's culturally difficult in many places to work with such things as planning for your own death, because that sort of means you're ready to die. So it's not hard then to view APRA in particular as the department's way of continuing a certain cultural imperialism that was perpetuated by allotment itself. Once allotment failed to free all Indian lands from Indian hands, something new had to be devised in order to complete, and I question that term, complete the assimilation process for those, relatively speaking, few Native people who had managed to defy the odds and hang on to their lands. In the main, landowner advocates argue that wills, gift deeds, land exchanges between and among family members and also with the tribes are the obvious tools that landowners must avail themselves of if they want to maintain or remain connected to their reservations in tangible ways, like having a place of their own. Anti-fractionation vehicles like the land buyback program provide, to me, what seems to be the opposite, and create a situation where landowners must trust that their tribal governments will do the right thing in providing, say, land assignments or some other attainable form of home ownership. It's so ironic that the United States used allotment to assimilate Native people, to separate and create a new kind of Indian individual from what had been, at least from the outside, a collective. And now that role, that position or tradition of individual ownership of the individual landowner has its own cultural saliency, that is, it's been appropriated for not just economic but also cultural survival. Now the federal government wants to be rid of it and to assimilate that individual into a newer kind of collective of the tribal member and to recollect what were individually owned lands under a relatively new form of tribal ownership, which is not necessarily a collective at all, of course, but corporate. And so this is a rub, or one of them, that many landowners say they don't trust their own tribal governments. So under this Western form of ownership, landowners are seen as having been assimilated to the extent that they identify with and value the ability to protect certain places that have familial and thus cultural significance for them. But then again, haven't individuals and families always sought to protect their use rights to, if not some form of ownership over particular places, access to which was then handed down through familial lines in a variety of traditional legal forms? So perhaps the real problem is just that the contemporary individual landowner has to operate under a constantly changing set of rules. Not only that, but the rules by which they must abide are different than any place else, probably in the world. So again, I'm reaching back a little bit in time here. Case in point, in 2008, Congress passed Public Law 110-453. Does anybody remember what that was? Probably not. It directed the Secretary of Interior to take into trust 2 parcels of land for the benefit of certain Indian pueblos in the state of New Mexico and for other purposes. Among those other purposes, sandwiched between the Albuquerque Indian School Act, which was Title I of the law, and the reauthorization of a memorial to Martin Luther King Jr., which was Title III, were a number of Native American technical corrections, Title II. And those were covering a variety of tribal appropriations, settlements, leasing authorities, and significantly, amendments to the Indian Land Consolidation Act. Buried in this ostensibly non-controversial series of strikings and insertions is a decidedly substantive addition regarding the inheritance of covered permanent improvements. That is, of permanent structures attached to the land, including houses and other buildings, but also things like fences, wells, well pumps, ditches, canals, things that add value to the land. On February 10th, 2011, the U.S. Department of the Interior published an interim final rule implementing these amendments. In this final rule, the department revealed its heretofore unspoken general rule that the department considers permanent improvements to be non-trust property and expects that such improvements be probated through state courts rather than through the department's probate hearings division at the Office of Hearings and Appeals, if the tribe doesn't have its own probate code. So while this bombshell landed rather lightly in Indian country, prompting one Indian landowner advocate to question how the announcement flew under Indian country's radar and what that might mean about the department's communication strategy, it nevertheless began to cause waves in federal agency offices such as DOI's Office of Hearings and Appeals, which immediately began treating houses and other structures on Indian trust lands as fee, that is, non-trust assets during probate. It was not until the fall of 2011, however, that a small group of Indian landowners began to sound an alarm about this explicit change in the department's treatment of Indian trust assets and the potential consequences for individual Indian landowners and tribes. In October, during the 21st Annual Indian Land Consolidation Symposium, Helen Sanders brought her concerns to the floor and asked her fellow board members with Indian Land Working Group to lodge a formal objection with then Interior Secretary Salazar. Earlier that same fall, Sanders had attended a BIA presentation on the Indian Land Consolidation Act and its amending law, American Indian Probate Reform Act. She said, I listened to their presentation and I said, you guys tell them, the audience, what the law is, but you don't tell them the effects of it. After prompting a more detailed explanation of what the new permanent improvement rule would mean to landowners, Sanders likened it to the department's single heir rule, a provision of APRA that was and still is vehemently criticized by Indian landowners because of its potential to pit family members against one another in an attempt to be the last man standing, which is Helen's more colorful and perhaps more accurate name for the rule. So why were landowners so alarmed? By late October 2011, Indian Land Working Group board members had submitted their objections to Interior, and by early November, they had successfully lobbied the National Congress of American Indians to also submit its own resolution, directing the department to place a moratorium on, or I guess asking the department to place a moratorium on the implementation of the permanent improvement provisions for the interim final rule. With both missives, while both missives pointed out the potentially harmful effects that the new policy could have on everything from OHA's probate backlog to the subjecting of permanent improvements located on trust lands to state jurisdiction and taxation, ILWG's objections went much further in detailing the possible consequences of the DOI's new rule. These concerns reflect the considered opinions of allotted landowners, tribal leaders, and representatives, experienced BIA realty staff, and executive personnel from across the country, that the department's unilaterally improvised treatment of improvements to trust land as non-trust assets is potentially disastrous for both tribes and individual Indian landowners and their heirs. Aside from this unique departure from widely accepted legal traditions, in which improvements to real property are themselves considered real, that is not personal property. The ILWG objections pointed out that the department's changes, quote, invite, if not solicit, already aggressive states to assert regulatory and tax jurisdiction over on-reservation assets and effectively revoke the heretofore existing trust tax exemption for such assets without compensation in violation of Supreme Court decisions. The letter cites Choate v. Trapp, 1912, in which the court recognized the non-taxation of Indian allotments as a property right, not subject to action by Congress, much less by regulatory erosion. Thus, the ILWG letter points out that DOI's general rule, idiosyncratically identifying improvements to allotments as non-trust assets, promises to affect another unconstitutional taking of a vested Indian property right, and here I'm thinking of the 2% escheat provision in ILCA, in the unamended ILCA. It furthermore warned that the effective revocation of tax exemption subjects the United States to a tsunami of individual legal claims by allotted landowners, dwarfing the Cobell litigation on the order of those seen on White Earth, on the White Earth Indian Reservation, which destabilized title to assets and resulted in costly labor-intensive settlement to the U.S. that's still being distributed. Following up, in March 2012, Indian Land Tenure Foundation submitted a lengthy comment to Interior Secretary Salazar on the department's Cobell Land Consolidation Program, the sort of precursor to the land buyback program. The LTF letter detailed the effects that the permanent improvements rule would have on the department's ability to use Cobell settlement funds to buy fractionated interests. And so I think it also would have the same effect on the land buyback funds. It pointed out that following the rationale of Public Law 110-453 and the rules issued, interests held in fee would include interests held in any permanent structure on trust lands, which by statute, DOI cannot purchase under the CLCP and so cannot purchase under LBBP either. This, of course, will lead to one of two outcomes rather quickly. Either the Interior will be limited to buying undivided interests in trust land without any permanent structures on it, no houses, barns, corrals, fences, wells, etc. Or there will be trust properties with one set of ownership interests and the permanent structures on the same land with a different set of ownership interests. It's likely that no one will ever track the ownership interests of the permanent structures until conflicts arise or substantial value is lost through sale. Perhaps because of the foregoing objections by landowners and their advocates and NCAI, in 2012, the BIA published a new set of regulations covering non-agricultural surface leasing, which became effective on January 4th, 2013. Section 162.017 of the rule states that subject only to applicable law, states and local governments may not impose a tax on permanent improvements on leased Indian land, regardless of who owns the improvements and other activities under lease, so on. So that's good. However, the general rule that permanent improvements are non-trust properties still stands, and the new regulations didn't address concerns over probate, as is pointed out by NCAI in a letter dated August 6, 2013. And according to the DOI's materials, their own materials, which were presented at the Indian Land Consolidation Symposium this past fall, the buyback program acquires fractional interests only in the land, not in the improvements themselves. Improvements are not appraised or included for purchase in the program offers, but are considered in determining the fair market value of the underlying tract of land. So time and actual buyback offers practice will tell what such consideration it actually ends up being worth on the market. Similarly, the recently released rights of way over Indian lands regulations comprise a situation that illustrates how the rules that Indian landowners must abide by are shifting and a world unto themselves, another situation in which that is true. created to streamline a process that already tends to move too fast. If you're an individual landowner confronted by a landman or an oil man or a utility company guy at your door, many landowner advocates see the new and improved rights-of-way regulations as yet another way to cut landowners out of decisions regarding their own land. Indeed, one of their criticisms is that the regulations were drafted without input from landowner organizations and individuals who were only given the chance to comment at the same time as the rest of the public, even though they were directly affected by these rules. The regulations specifically target owners with fractionated interests, that is, greater than 50 owners, as representing or as presenting impracticable barriers for potential lessees, such that the Secretary is empowered to grant or reject rights of way without landowner approval or even consultation. I just keep having to ask, why is it that Indian landowners are targeted with what seems to be one experimental fix after another? When placing APRA, the Permanent Improvement Regulations, and new rights-of-way regulations in context, and the rights-of-way regulations won't go into effect until March, so there's still ostensibly time for some comment. So putting all those things in context, both historical and cultural, it's not hard to understand why some of the most engaged landowners, like the Beckwiths, Terry and Leela, who some of you know probably from ICC Indian Enterprises, they see what they call a new form of termination in their future. All told, Terry and Leela Beckwith have more than 70 years of experience in Indian realty and related fields. When they retired from federal service in the mid-1990s, their accumulated experience provided the expertise, not to mention the motivation for what they did next. They took their show on the road. Since 1998, the Beckwiths have spent the majority of their days traveling from reservation to reservation, spreading good-natured goodwill wherever they go, providing training for BIA and tribal realty staffs nationwide. Through their consulting firm, ICC Indian Enterprises, they offer courses and certification programs to suit every need presented in the complex netherworld of federal Indian real estate. The fact that they provide this service to tribes and the BIA employees hardly needs explanation, but I guess I'll provide it anyway, that professional training opportunities in federal Indian realty services hardly exist unless a tribe provides them for its own people. The fact that the Beckwith services are in high demand by employees and others of the BIA and other federal entities whose mission is in part to carry out the responsibility to protect and improve the trust assets of American Indians, Indian tribes, and Alaska Natives seemingly requires some explanation. Other federal entities commonly provide specialized training for their staffs. For instance, Indian Health Services Resource and Patient Management System offers 50 different classes open to affiliated individuals. But one is hard-pressed to find professional training opportunities for government personnel tasked with carrying out realty-related duties imposed by the federal government's relationship with individual Indian and tribal landowners. Aside from demand, the Beckwith's motivation for providing such training opportunities, that is, for sort of helping the United States federal government perform one of its central responsibilities with regard to trust landowners, comes from experience. Thinking back on his own career, Terry Beckwith writes, it was Sunday, January 7th, 1973. It was my first day on the job with the new Office of Hearings and Appeals. We left Portland early that morning for Spokane for probate hearings. It was in a restaurant in Umatilla, Oregon, halfway through a cheeseburger and fries, that I asked my first realty question: what exactly is probate? This was the way the staff learned Indian realty. We learned realty on the job by processing legal transactions and by asking questions and making mistakes. Some of us were lucky to have experts to teach us, some were not. Terry's career took him and Leela from the Pacific Northwest to Oklahoma, to Arizona, to Central and finally Southern California, where he finished his career as the director of the Palm Springs Field Office, now Palm Springs Agency. He expressed his shock at the irregularities he encountered along the way. having spent the nearly 20 years since their retirement training Indian realty staff all over the country, the Beckwiths have found that the problems Terry encountered throughout his career are widespread. Terry explains, and this is Terry's words, there's a lack of trained staff to provide the services in a very complex field. The staff at the top level of the Department of the Interior still does not understand the complexity of Indian realty, even after Eloise Cobell's breach of trust lawsuit. The interesting thing is that people like Terry and Leela look at the current state of affairs in the Federal Indian Individual Trust as an opportunity to educate and empower landowners, to revitalize the language and lived experience of stewardship and place-based sensibilities, to turn termination into self-determination. I think I had that here. Uh-oh, I just lost my place. This is from a newsletter that they put out I think it's quarterly that it comes out. And I just lost my place, so I'll be right back. I hate it when this happens. Here we go. So to turn termination into self-determination. And this is something they have written and spoken about pretty widely. I imagine some of you have been involved in some of those trainings. And there's a lot of energy there. Likewise, and similarly, the landowner and advocate Theodore Birdbear of MHA Nation says, we need to start with the 0 to 5-year-olds educating the new electorate. This reminds me of language revitalization efforts, the intent of which is to create new generations of fluent speakers, beginning with the very young. By contrast, landowner revitalization efforts are seldom, if ever, directed at the young, with the exception of tribal programs like what Theodora Birdbear describes. And she says there's a lot of work to be done with that group. She says to bring them up as educated, empowered individuals who are ultimately connected to their communities and to their lands. But if people sell their lands, then there is literally no basis for revitalization. How do you revitalize something that you no longer have or have any hope of having control over? And of course, that could be mitigated by tribal land assignments and things like that. So, to move along, Indian Land Tenure Foundation, for instance, does provide some resources for such work. Here's you can't even see that, but I'm sure you're aware of their pretty extensive website and the curricula that are available there for a variety of age groups. And they're always adding to that. Many of those pieces of instances of curricula, of lessons, come from tribal communities themselves. So Indian Land Tenure Foundation provides some of those resources. As I said, the Indian Estate Planning Manual developed by ILWG a number of years ago is also up on Indian Land Tenure Foundation's website. They have helped put grants toward this. I know ILTF, I think, I don't know if this in particular, if they've contributed to this, but also to will writing efforts here in the Southwest, to work being done up on the Pine Ridge Reservation with the Village Earths nonprofit organization, and manuals like this one, map book, dedicated to helping landowners understand their own land, where it's at, how much they have. We've tried to do something different but similar at Fort Hall. This can be made available. It's not up on the internet right now, but this is curriculum that we developed when I was working there at Fort Hall for high schoolers, junior and senior high schoolers, to begin to understand how to find out about your own land, how to, and this is stuff that can, of course, be spread across the curriculum. It's everything from math to geography to ecology to you name it. You can pull it in there, history, social sciences, all of them. And teaching kids how to read their maps and asking them to go and interview their elders and things like that. So getting people interested at a young age about their land and getting them to maybe go find out where it is. And if they haven't already done so, to spend some time on it. So these are, a lot of this stuff is mainly for olders and elders, but there is some stuff there for the youngers as well. And then, of course, the work that we've done at MSU and would like to continue doing, actually, in providing just fact sheets for people to go and these, yeah, you can't even read that, can you? That's the same thing, basically, in another form, fact sheets. So I know there's a lot more happening out there, and to get back to the question of the day, the question of alternatives, and like I said, these are alternatives from landowners, because, as I said, it's the landowners that are coming up with the good ideas. That there's that the only alternatives really to the will writing, especially in this new world that was created by APRA, where you better write a will or you'll end up in being covered by APRA, and other evolving regulations like those I mentioned, is what I like to call the Helen Sanders alternative, which is get rid of everything before you pass. Grant, gift, deed it away, trust, put it in a family trust if you need to, so that there's nothing left to pass under APRA if possible. And she did that and has just a life estate at Chehalis now. But of course that was hard enough for someone like Helen, who has a lifetime of dealing with such issues and with bureaucracies, the bureaucracies associated with them. And so the issue here, as was the case with her estate, and I do have her permission to talk about this, landowners often seem to run into a reluctance in the form of bureaucracy and red tape, given that Interior doesn't consider anti-fractionation vehicles like family exchanges and gift deeds to be consolidation, because land interests can still fractionate, again, under individual ownership, which is an issue that can be mitigated, too, through family trusts or corporations, which are an option under APRA. Terry Beckwith, for his part, advises that if you do write a will, leave any interest less than 10%, not 5%, but 10% to one person. And he says, nothing less than a dime, trying to teach people how to read and understand the decimal system. Nothing less than a dime to one person. So again, coming full circle, the DOI only regards tribal ownership as consolidation, which again I find to be an awfully ironic twist, considering not only the assimilationist history of allotment, but the fact that Cobell was brought by and on behalf of landowners, not tribes. Individuals labored for generations under that experiment, which by most measures failed, but by others didn't. And now individuals are being encouraged to participate in a new experiment. This one, devised ostensibly to consolidate fractionated interests, will not. The head of DOI's land buyback program himself stated as much. And then he followed that with a question: what next? So what next indeed, especially for those landowners who have only been warned of what might happen next if they don't sell, not what happens if they do. What next? Are we done? I could go on for a while, but I saw you coming over there, and so I wondered.
Coming up here to yank you off the stage.
Get the hook.
We have time for questions, so if you're amenable.
Sure.
If you don't raise your hand up right away, I know the drill. Take your time, thinking about the question. And I will wait, so don't worry about it.
Like a good teacher.
What?
Like a good teacher.
No, like a good student of art, of culture, and Indian culture.
Wait.
Knowing when to just wait and relax, and it'll come. I have a question. Oh, we have a question.
Jim.
Who was
Jim.
there? I
Jim.
didn't see.
James.
Jim.
Just, and it's more of a comment, but just, you know, Kristen's right, that the buyback program has this perception of land consolidation only being focused on tribal acquisition and tribal consolidation.
Right.
However, the work that we have been doing with the Office of Special Custody and the Bureau of Indian Affairs and Indian Country and ILTF and others is to note that the land buyback program is but one of the tools that's out there in the array of tools for individuals to control their property. And certainly, one of the things that we hope folks will do, and the buyback program, even though it's focused on the tribal aspect of it, can't deny that consolidation, when it occurs within families or within individuals, is indeed consolidation as well. So just, you know, wanted to throw that out there, and I know you're correct in what you said, but there are other options.
And I appreciate that, and that was also made clear when, what's his name, John McClanahan spoke about the program and, and the land buyback as being just one option. I guess the hard thing is that there's no money that is following the other options. You know, the only money there is for the tribes to do consolidation, and I think I'm no longer on this, but I think the tribes obviously need to be part of that process, and there's some of the consolidation that can maybe only happen in the tribes. It just would be nice if landowners had more help.
And just a quick follow-up to that, there is a listing conference coming up in Albuquerque on March 3rd, I think. And that would be a tremendous opportunity for landowners to make that point.
Okay.
That is a very valid point. Yeah.
Great. I'd like to get more information about that, and I can help spread the word. There's another question?
My question is, how realistic is that option? I mean, does Interior have a policy that if one of the co-owners wants to consolidate that land interest and he has the money, will they allow him priority to go ahead and make that purchase?
So the landowners have, my understanding is that once an offer goes out to a landowner to sell your land, you have 45 days to get on it and make offers to your co-owners before the tribe does. So time is not your friend. They won't stop you from doing that, I don't think. But there is that option. It's just that you have to be. And so I think what people like the Beckwiths and others are saying is that talk with your co-owners if you can find them, if you know who they are, and you do have access, you do have a right to that information, to talk with them and find out if any of them are willing to be bought out, if they are thinking about maybe participating in the land buyback program, and then see if you can. Terry Beckwith actually suggests, and this isn't an option for everybody, but he says create a Facebook page with your family members and try to get in touch with people, because people are so far flung. They may be all over the country, just so that you can be in communication with them and find out what they're thinking. So I think it's an option, not a great one. I'll be around.
Feel most comfortable.
Okay, for instance, if a tribe sends a letter to the families, but they don't give, they know who the owners are, why can't the own individuals get the owners' names?
You can.
Did everyone hear the question?
Oh,
Is the mic,
So when they do an offer, like you said, you have 45 days to contact the family. You can't
Right.
get a hold of the family, only the tribes have the names of the families.
so by law, you have a right to your co-owner information, who they are and how to get in contact with them. That was clarified actually in a case that came out of Fort Hall and the Fort Hall Landowners Alliance. You have that right. And I think that's part of this process is landowners being educated in that way about what your rights are and then standing on that and exercising those rights and saying, no, I need that information. You probably need it now.
Yeah, because my family
Right.
is having this issue right now where they're not giving them the information of the owners.
They-
Also, the fact that 6 of the owners are selling it, they won't give them that information to who they are.
They have to.
They haven't. So we'll talk later about this.
Okay. Yeah. I can't believe that's still happening.
Yep, it is.
yes, sir.
What's the legality of not using certified mail and using that post date as 45 days?
That would be a great question for a lawyer.
Okay.
So they come without certified mail.
So my question is, what did I say?
What's the legality of...
What's the legality of, it not using certified mail and using that post date as the start of the 45 days for the allotted interest owner?
I would only be able to speculate on that. So I don't know if you want speculation. Speculate. He says speculate, so I will. I would say that keep that postmark, keep that because that's all you've got. I don't know why they wouldn't send it certified. And maybe that's something that would be good feedback for the department officials involved with the program is send those things certified mail, which is probably an increased cost. Anything else?
Yeah, we're going to wait just a second, yeah. Well, I have a question. I don't know if you know the answer to this, but if there are any folks out there from administering the Cobell land buyback? I know that you're involved with the Navajo from the Navajo and individual tribal interests. But what if you're an allotment owner and you've been disenrolled?
So
And can you then still take part in it, or is it, or do you lose the right to go ahead and participate in?
I think it depends on your degree of consanguinity, so how far you are from an enrolled member. So if you're still just one relation away from, or up to 2 relations away from an enrolled member, you should still be able to participate, as far as my understanding goes.
Right. What Kristin brought up too was the cultural importance of the land and the intergenerational memories that are associated with that, and the codes of conduct, the laws that come from knowledge and understanding and relationship with the land too. And so mapping intergenerational memories as part of this gathering of family members as an alternative, I think is also critical and very important. There's a man named John Burroughs, B-O-R-R-O-W-S. He's, I think, the foremost Aboriginal law scholar in Canada, and he writes extensively on this. And I would direct you to his work as well.
Great, thank you.
Yes, sir.
I have a question on the Office of Hearings and Appeals approach to improvements now. Based on your what you're saying, Interior will not assert a trust responsibility over improvements.
Right.
So does Office on Hearings Appeals now have a blanket approach that they will not probate airship to improvements in the probate process?
That's my understanding. Is there anyone here from OHA? Not much of an answer, is it?
Well, why don't we take one more question, if anyone has it out there, and then we're up for our next drawing and a break. And while we're waiting for that question, I'll let you know the restrooms are just out the door and to your left. Some of you have been cross-legged for about the last half hour.
Break.
All right, well, we can go ahead. If you think of any more questions, we'll continue there. So, Kristin, thank you very, very much. I appreciate it.
Thank you all. I appreciate your audience.